allegedly because of suffering from abuse from her home. Also in the article, Your Excellency, it was stated that the child's mother is being searched by the police because she accidentally killed her child by belting the child or hitting the child with a belt numerous times at various areas of her body just because of misbehaving. Your Excellencies, the child name was Kate and she was 5 years old. And this is just one of the many consequences of corporal punishment.
Counsel, before you get there, it seems that you're discussing the worst case scenario, which we have to admit doesn't really happen that much. Like parents accidentally killing their children. We're talking about the gray area, the middle ground, what they are talking about, reasonable corporal punishment. Assuming it does not lead to death or abuse of the child, is it still something that has to be done?
Of course, Your Excellencies, respondent still emphasizes that the state has to be hard put in banning corporal punishment because we do not want to risk any kind of detriment that will encroach on the best interest of the child. Your Excellencies. Your Excellencies, this is, of course, it can be contended that this might be an isolated case. But if this is an isolated case, Your Excellencies, then why is it that according to the DSWD, their updated reports, that there were 939 cases of child abuse recorded in the years 2009 and 2010, and 587 of these 939 cases were reported to be domestic child abuse. Your Excellencies.
Speaker, is it your contention then that because an activity is prone to abuse, you should necessarily ban it?
Your Excellencies, in light of the best interest of the child, yes, Your Excellencies, in light of corporal punishment, which can lead to high risk to the welfare and development of the child, yes, Your Excellencies.
Counsel, the data that you submitted a while ago from the DSWD, does this mean that all those cases are actually cases of corporal punishment and not other cases of child abuse?
The 939 is child abuse in general, but the 537, Your Excellencies, are recorded to be, yes, child abuse from domestic homes, recorded from the years 2009 to 2010. And in addition to that, there was also an update that another additional 51 cases was added to this 500 just this month.
A law is effectively curtailment of one's freedom. Are you aware of that? The law is a limit to one's basic freedom, like a parent. Do you agree that the responsibility to raise the child belongs to the parent?
Yes, Your Excellency.
And therefore, the responsibility is a corresponding. There has to be a right attached to it, because how can you be responsible for something which you cannot freely exercise? How would you reconcile the responsibility of a parent and the curtailment of freedom to discipline the child as what we are trying to oppose today?
Yes, Your Excellencies, pursuant to law, the parents does have a natural and primary right to rear the child in the best way they deem fit, rather, Your Excellencies. But it should be noted that also the state takes part also in protecting the best interests of the child as parents factually, Your Excellencies.
Who has the basic responsibilities? The state or is it the family or the parent?
The family, Your Excellencies, but the state also has to regulate and to ensure the best interests of the child.
Given the situation that the state has a macro viewpoint and a parent has a particular concern to a child and is in the best position to understand which is best for the child, are you still saying that it is the state's supreme power and duty to curtail the basic freedom of the parent to discipline the child?
Only in instances, Your Excellencies, wherein their children, the best interests of their children are already at risk, Your Excellencies. But in the manner in which, for example, the parent chooses what school the child wants to go to, that already belongs to the parent. The state no longer has a hand in choosing those kinds of decisions. But if it's already in a decision which already, Your Excellencies, put a risk on the best interest of the child, then the state has even a constitutional mandate to step in as parents patriae to protect the best interests of the child, Your Excellencies. If I may proceed, Your Excellencies. Thank you, Your Excellencies. Your Excellencies, it should be noted, Your Excellencies, that physical abuse happens at the very first instance of ordinary physical punishment, Your Excellencies, that you cannot disagree with, that it can inevitably lead to excessiveness, Your Excellencies, which is detrimental to the child. So respondent proposes, Your Excellencies, that it is better for a full prohibition. That way, we do not put any risk whatsoever, Your Excellencies. Regardless if it's just one slap, regardless if it's just a subtle slap, Your Excellencies. That kind of act will certainly lead to other acts of violence which can exceed to the reasonable corporal punishment, so to speak, that people who invoke corporal punishment tries to affirm, Your Excellencies. Your Excellencies, now moving on to my second submission, if there are no more questions, that there is a necessity, Your Excellencies, to rid the Philippines fully of corporal punishment pursuant to domestic and international law and also based on studies. Your Excellencies, based on the studies of Strauss and Stewart,
Actually, I'm interested in hearing how you address the progressive realization point that was presented by applicant earlier.
Progressive realization point.
The applicant simply said that in the Convention on the Rights of the Child, we're not required to apply it wholesale. We can still have certain steps where we take gradual methods towards development. So they said corporal punishment is not something that we're ready to get rid of, according to the progressive realization argument. How do you address that?
Your Excellencies, the Philippines being ratifying the UNCRC and also the ICCPR, all international laws, are evidently signatories of these laws. Thus, they have a duty to actually refer to these laws and actually adhere to these laws that cater to the best interests.
But the law itself provides for certain leeway in margin of appreciation or progressive realization. So it seems that even the law allows for a margin of development for states. So aren't they correct in this regard?
Your Excellencies, even if Your Excellencies, if you would see, other states have employed the full prohibition of corporal punishment.
Precisely, Council, the basis for that doctrine is it realizes the cultural and societal differences between countries, thus allowing them to amend their laws accordingly at their own pace.
Your Excellencies, but in light of the best interest of the child, if this already puts risk to the child, wouldn't the state agree that it is better to take immediate action on the matter, Your Excellencies, taking into consideration the many reports of child abuse, especially in the home? I think if the state has time to enact laws, for example, to build buildings or to enact programs for development, I think, Your Excellencies, to pursuant to law, international and domestic law, I think they should also give an immediate care to the best interest of the child. Your Excellency, seeing that your time is up, may I please ask for a 5-minute extension?
Let's give you the same extension that we gave to the other team. What's the extension that we gave to the other team?
Thank you, Your Excellencies. If I may proceed, Your Excellencies. According to domestic law, Your Excellencies, the state, as parents patriae, has a right or an obligation to step in whenever the way parents rear the child is already abusive in nature, Your Excellencies. And according to also the Constitution, Article 2, Section 2, we are also bound to international law, Your Excellencies. That means, Your Excellencies, being signatories of the ICCPR and the UNCRC, Your Excellencies, we are obligated to outlaw such acts that may pose a risk to the best interest of the child, Your Excellencies.
It's not by you, so very correct.
No,
You're
Your
saying that